Hello and welcome to the Minimum Competence episode for Wednesday, December 3rd, 2025. I'm your host for today, Andrew Leahy, an assistant professor of law at Drexel Klein School of Law. On today's episode, a Medicaid funding block, a purge of New York City immigration judges, and a DC shooting suspect's not guilty plea that's sparking political backlash. Let's remember, in recognizing the humanity of our fellow beings, we pay ourselves the highest tribute. And read today's legal news. On this day in legal history, December 3rd, 1946, the NAACP filed the pivotal case Morgan v. Virginia, challenging state-enforced segregation on interstate buses. The case arose after Irene Morgan, a black woman, refused to give up her seat to a white passenger on a Greyhound bus traveling from Virginia to Maryland in 1944. Arrested and fined under Virginia law, Morgan appealed her conviction with the support of the NAACP Legal Defense Fund. Thurgood Marshall, who would later become the first black Supreme Court justice, argued the case before the U.S. Supreme Court. The legal argument hinged on the Commerce Clause of the U.S. Constitution, which grants Congress, not individual states, the power to regulate interstate commerce. Marshall argued that Virginia's segregation law placed an undue burden on interstate travel and was thus unconstitutional. In a 7-1 decision issued in June of 1946, the court agreed, holding that states could not impose segregation on interstate passengers. Though the ruling did not end segregation on all public transportation, it was a critical legal breakthrough. It limited the reach of Jim Crow laws and marked one of the earliest Supreme Court victories for the civil rights movement. The decision also served as a foundation for future rulings, including Boynton v. Virginia in 1960, and inspired direct action like the Freedom Rides of the early 1960s. Morgan v. Virginia helped establish a constitutional framework for challenging racially discriminatory laws under federal authority. It demonstrated the NAACP strategy of incremental legal challenges and the importance of judicial victories in the broader civil rights struggle. A federal judge has blocked the Trump administration from enforcing a law that would strip Medicaid funding from Planned Parenthood and similar organizations in 22 states. U.S. District Judge Indira Talwani ruled that the provision, part of the Republican-backed One Big Beautiful Bill Act, likely violates the Constitution's spending clause by retroactively imposing ambiguous conditions on state Medicaid participation. The law bars Medicaid funding for nonprofit reproductive health providers that offer abortions and received over $800,000 in Medicaid funds during fiscal year 2023. Talwani issued a preliminary injunction temporarily halting the law's enforcement in the states that sued, including California, New York, and Connecticut, along with the District of Columbia. However, she stayed her ruling for 7 days to allow the Trump administration time to appeal. The judge warned that enforcing the law would increase healthcare costs and reduce access to preventative services like birth control and screenings. Planned Parenthood welcomed the ruling, calling the law unconstitutional and harmful. The organization reported that at least 20 health centers have closed since the law began taking effect in September. States argued the law forced an unexpected change to Medicaid operations and undermined their authority to choose eligible healthcare providers. The Trump administration has dismissed at least 7 immigration judges from New York City's immigration court, located at 26 Federal Plaza, a central site for immigration enforcement and protests. This move is part of a broader pattern under President Trump's second term, with over 100 immigration judges reportedly removed nationwide since January, according to the American Immigration Lawyers Association. Critics say these firings are worsening backlogs at a time when arrests and deportations are only increasing. Immigration judges operate under the Department of Justice, not the independent federal judiciary, and are considered inferior officers who can be dismissed by the president or attorney general. The Justice Department declined to comment on the terminations to Reuters, and among those fired was Amina Khan, the court's assistant chief immigration judge and former president of the National Association of Immigration Judges, who had previously opposed efforts to dismantle the judges' union. Khan and 6 other judges, all women, had their names removed from the court's staff directory, with 5 appointed by Democratic administrations and 2 during Trump's first term. These dismissals follow similar firings in San Francisco, Boston, and elsewhere. One former judge in Ohio has filed a lawsuit alleging her termination was due to discrimination based on sex, national origin, and political beliefs. Ramanullah Lakhanwal, the suspect in a deadly Washington, D.C. ambush that killed one National Guard member and critically injured another, pleaded not guilty during his first court appearance. He participated remotely from a hospital bed and was ordered held without bond due to the violent nature of the attack, which occurred just blocks from the White House. The judge cited the sheer terror of the incident in denying release. Prosecutors alleged that Lakhanwal, a 29-year-old Afghan national, traveled from Washington state to D.C. with the intent to carry out the shooting. He reportedly opened fire while shouting Allahu Akbar, fatally shooting 20-year-old Sarah Beckstrom and injuring 24-year-old Andrew Wolf, both West Virginia National Guard members, deployed to aid law enforcement. Lakhanwal was subdued by military personnel and a Secret Service officer after being shot. He faces 4 charges, including first-degree murder and assault with intent to kill while armed. Lakhanwal's defense highlighted his lack of criminal history, but prosecutors emphasized the premeditated nature of his actions. His immigration status has drawn political attention. He entered the U.S. under a resettlement program launched during the Biden administration and was granted asylum under Trump, making the case a focal point in renewed debates over immigration policy. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, you do what you think is right and let the law catch up.